issue, but I actually am not doing this in my own home. This is my best friend's house. We are currently load shedding. So she has so gracefully agreed to let me drive to Joburg to let me use her place.
Unfortunately, sorry, go.
Sorry, Lee. No, I was just going to say, I'm also going to be load shedded in the middle of the sessions at my office on a Friday night. It's great.
Oh, no.
And I've luckily had my session for the day, well, until midnight, so I'm good to go for now.
I live in the city, so I never have load shedding.
We had load shedding when I went to sleep last night, which was 12 past 2. I woke up to load shedding. It was 8 to 10:30. And I have load shedding at home now, 4 to half past 6. So Eskom caught me big time.
And at least that's one small benefit of Durban. We only have 2-hour sessions. I think you guys in Joburg have 2.5. So we have 2-hour slots. So it's maybe not quite bad.
Hello, everyone. Hi, Yukthena. So we can actually go ahead now.
Okay.
Yeah, thank you so much.
Will you just give me a prompt on when to go, or?
Please go ahead. Thank you.
Thank you. So good evening, everybody, and thank you for joining us this afternoon. We're going to be doing a panel discussion, and this is part of a discussion series and also panel sessions for the Innovation Law Club, which is organized by the Innovation Law Club virtually. We're going to touch on some very interesting matters today, a lot of matters that are abuzz in South Africa at the moment, that being the Protection of Personal Information Act, the Cybercrimes Act, which it's interesting now to see that that bill has now been signed into law, and also to look at the future of information security in South Africa. So it's a loaded session, lots of information. You will be able to ask questions. If you've joined on the Zoom platform, you will note that there is a question and answer set up, so feel free to post your questions, and as we proceed through the presentation, I'll be able to give those through to the panel to be answered. So yes, we have some incredible panelists with us today, and I'll introduce them one by one, and they'll also be able to give us a nice background of what they do and the type of experience that they have. So our 3 panelists for this evening, it's Dr. Lee Swales. He is a consultant attorney at Thomson Wilks, as well as a senior law lecturer at the School of Law at the University of KwaZulu-Natal. And we have with us the second panelist, who is Advocate Lufuno Tshikalange Khorommbi, who is a cyber law consultant and the managing director at Orizur Consulting Enterprise. And finally, we have Rakhee Dullabh, who is a director at ENSafrica. To introduce myself as well, my name is Yukthena Sibran, and I am the compliance officer and company secretary at Sandvik Mining. And I'm involved in the compliance space as well as in terms of governance and risk. And yes, I have quite a fondness for compliance and data privacy and looking at the new developments in this field. And yes, it's a big passion, I think, for everyone today. If I can maybe hand over to Lee. Lee, can you maybe just give us a little bit of a breakdown of who you are today?
Sure, thanks. So thanks for inviting me to join. I'm happy to be here. I started out my professional life actually as an IT expert. So I worked in London at Heathrow Airport as an IT support tech. So I started as a techie, then I moved to law. And so I've always tried to mix law and technology. I did my articles at a large firm in Joburg, worked up there for a while. And I now mix the practice of law at Thomson Wilks, where I focus on commercial technology related issues. And I teach at the University of KwaZulu-Natal. I teach cyber law, contracts, an advanced contract. So yeah, I've got a tech background. I'm interested in technology, and I try to involve myself in matters that relate to technology and the law.
Brilliant. We look forward to leveraging of all this expertise tonight. Perfect. Advocate Lufuno, if you can tell us a bit about yourself, your experience and your expertise.
Thank you so much for having me here. My name is Lufuno Tshikalange, my second name. So yeah, to avoid people having to twist their tongue, it's just better to say. And yeah, my surname is Khorommbi. I studied law first, and then I did IT, not the IT that Dr. Swales did. After I graduated from the law school, I was recruited to do an internship program with the then Department of Communication. And the intention was to train us to be cyber lawyers. So I found it to be interesting. And since then, I've just been stuck with this IT law thing. So yeah, I think to be in the IT space and in the legal space, it gives you a bigger spectrum to contribute to what the country is doing in as far as the cybersecurity is concerned. So yeah, I like it. I'm also doing a research on the legal aspects of cybersecurity within e-governance. So I believe Dr. Swales will be a very good person to consult when I'm stuck. Thank you.
Brilliant. I see Lee says he's very happy to help you. And our final panelist for this evening is Rakhee Dullabh. If you can tell us a bit about your skills and experience.
Hi, thank you. Yes, thanks for having me. Looking forward to the conversation. It's always nice to talk to like-minded people about all these very fascinating and complex issues. I'm a director at ENSafrica, part of the technology, media, and telecommunications team. I specialize in data privacy law and everything to do with tech. I don't think you can do tech law and not have an interest in the technology itself, and that's where it's all born from. So fundamentally, yes, the first love is always tech, but data privacy is really challenging that first love at the moment. It's very engaging, but now being on the 11th of June, I'm starting to feel like I need to run away for a while and come back to work in July. Things are slightly manic in terms of advising clients and trying to assist organizations in getting there. I'm sure in the session you'll hear a little bit of the war stories that we're facing, but it's absolutely fascinating, and I don't think it could have come at a better time for all of us in our careers. We've been looking forward to it for years. We've been trying to predict with our crystal balls, and nobody could have predicted this. So yeah, thanks.
Brilliant. Thank you so much, Rakhee. I can tell, just being someone who is thoroughly fascinated and intrigued by the intricacies of data privacy, data protection, having data subjects, having so many rights now that have come to the front line. I think the best place to start will be, and I'm going to throw this, we started with you, Dr. Lee Swales. So I'm also going to give you a chance to open the floor. So seeing as we are going to be talking a lot about POPIA and the Cybercrimes Act, could you please enlighten us on the differences between the concepts of data protection and cybersecurity? And maybe you can explain if these concepts overlap at all, or if they're completely different.
Sure, thanks. So I think they definitely, the concepts definitely do overlap, and they are quite similar, but there is clearly a distinction that you can draw between the two. So let's start with data protection, given that we're talking POPIA's compliance date is just around the corner. And effectively what data protection deals with is the responsible handling of data. So that's the collection of it, the processing of it, the storage of it, how a person and an entity goes about dealing with personal information, and in terms of South Africa's legislation, special personal information. We are, as we know, on the edge of POPIA becoming fully effective, and that's the primary mechanism that regulates personal information. Prior to that, it was a bit of a hodgepodge, and we had certain pieces of legislation that had an effect, but this is the first time we're going to have an act that directly regulates this. We're following our international compatriots, such as the GDPR in the EU and the California Privacy Act in the United States, and it follows a long history of instruments. So primarily what we're looking at is dealing with data responsibly, and this is traditionally perceived to be an area, data protection, that's all about safeguarding and dealing with data responsibly. So data being the key and personal information being the key. Whereas with cybersecurity, I think arguably it's a little bit broader, because now we're looking at an entire electronic network system. So we're looking at a network, we're looking at the devices, we're looking at programs, and obviously the data that sits in those networks and programs and devices. So cybersecurity is probably a little bit broader, and we're looking at protecting the network and the data from attacks such as malware, cloud vulnerabilities, denial of service attacks. And today, what's a big problem is actually social engineering. So it's usually the people that are the weakest link, not really the technology. So that's now regulated by the Cybercrimes Act. Well, it will be soon. The president needs to tell us when that's going to be in play from. But that traditionally was seen as a technical part of the profession, and that you have an IT expert who would deal with cybersecurity, and then you'd have someone different, a different team in the past dealing with data protection. But I think these days there is an overlap, as you say, because although they are different, there's certainly an overlap, and you would certainly want in any organization the IT experts on the same page as the legal experts, as the same page as the HR experts. It needs to be one holistic strategy. So to answer your question in a short way, there's definitely a distinction, but there's a large overlap between the two, with data being at the center of the equation.
Okay, brilliant. I think that definitely can get our ball rolling now. So I'm going to throw it next to Rakhee. We understand now Dr. Swales has explained these concepts. I think it's a great time now for us to understand a high-level overview of the South African POPIA, so the Protection of Personal Information Act, and our new Cybercrimes Act. Now, here's some of the questions that I'd like for you to cover. Why do these legislation exist? What do they seek to achieve? And again, just like I posed the question to Lee as well, are there any overlaps between them that you can explain to us?
Okay, so a loaded question. I don't know how much time you have. I do these in 2-hour bits, and even then we don't get to everything. But yes, so correctly and exactly as Dr. Lee has mentioned about, the way that personal information needs to be distinguished from cybersecurity, and leaning from that, we have never had comprehensive laws dealing with processing of personal information. We've never had clear direction from legislators about how to give effect to one of our fundamental constitutional rights to privacy. It's been dealt with in pockets, and funny enough, I think it may not have been as important a good few decades ago when these issues were contemplated. It was never top of mind. But like we all know, technology really makes everything so exciting and really sped up the process in understanding what was required in order to be able to manage this new world in which we find ourselves in. You would have heard the phrase that data is the new oil. And as we've started mining all of this data, working with data, manipulating data, commercializing data, there's becoming an increased overlap in overriding people's privacy in the world, because that data relates to people, and the aim is to target people to buy more things. I think that is the fundamental basis of business these days. And so in this sort of environment, in this new ecosystem, there is a profound need to set boundaries as to how people can use data, continue to manipulate data, but still respect people's like fundamental right to privacy. And so that's what the law intends to govern. It is not meant to hinder business. It's not meant to restrict us from doing what we need to do, but it is meant to ensure that we are responsible in how we conduct our businesses, as we would in terms of occupational safety and health, in how we look after people when they come into our premises. In the world, in the digital world we're working and the way we process information, we equally need to be responsible in how we process personal information. So POPIA gives effect to that right, and it sets out the 8 processing conditions as to how we can achieve that lawful processing of personal information. And I guess that sort of covers at a very high level what the law seeks to achieve. It does also deal with ancillary aspects, but very importantly related aspects over and above the 8 processing conditions, things like direct marketing, automated decision-making, transfer of personal information out of South Africa. Those are all related aspects in how to process personal information. Okay, so moving from there to the Cybercrimes Act, also similar in the form of where the history of it has all come from. As being in South Africa, we are actually, these stats might be a bit outdated, we were the 3rd highest ranked country in the world in terms of cybercrime attacks. We experience these on a daily basis to the point where people are so desensitized to cybercrime attacks in South Africa. I mean, if you talk about identity theft, people being married to people they never knew of, all of those were forms of, cybercrimes that were taking place. And up until now, we haven't had very detailed laws giving effect to that. Similar to personal information and the processing of that, there has been pockets of this. So the Electronic Communications and Transactions Act, many people don't even know, has a whole section dealing with cybercrimes. It's a very short section, but there is a section codifying cybercrimes. But they haven't been given effect to in a way that gives remedies to citizens, to people affected by cybercrimes. And as we move into the digital world, the prevalence of cybercrime attacks are completely sort of outweighed by what they used to be back in the day. So at the moment, I'm sure everybody's heard the phrase, it's not about if you're going to suffer a data breach, it's about when you're going to suffer a data breach. So it's almost a certainty in some way or form that someone will, be affected by cybercrime. And so the Cybercrimes Act codifies the fact that certain acts are offenses and they give effect. Fundamentally, that is the purpose of the Cybercrimes Act. It also creates certain structures within the public body space. So it creates these task forces, these institutions that are going to be able to actually deal with the cybercrimes. Because it's one thing to say you're guilty of a crime. It's another thing to progress that and actually give justice to people who have been harmed by these crimes. So that, I think, sort of hopefully positions the 2 laws.
Thank you. That's brilliant. You took, I think, a charged and a loaded question and you broke it down simply that anybody could have understood that. So thank you. I think we're getting into like the crux of this now. So I'm going to throw questions out now to the panel being Dr. Lee, and we're going to go to Rakhee, if you could tell us a little bit about what do you think is the most interesting provisions of POPIA? But then also, it's not the first time that we're seeing data protection laws and regulations. We have the European GDPR, so the General Data Protection Regulation. So I think for bigger organizations, but also for the smaller organizations who are GDPR compliant, does that automatically mean if I'm GDPR compliant as a business and my structures, my framework, and my procedures are GDPR compliant, or even just from a systems perspective, if you're GDPR compliant, does that automatically translate into POPIA compliance? And if it doesn't automatically translate into POPIA compliance, what further steps should be taken to ensure POPIA compliance? So yes, your favorite or your most interesting, you can throw out some tidbits that you've come across in your practices, what's interesting to you, but also I think we're all asking ourselves now, having gone through a lot of those processes in our own organizations, if I was GDPR compliant to begin with, should I be fine with POPIA? Oh, you need to break this down for me and the public, who I think will be very interested to know. So Dr. Lee or Rakhee?
Okay, I'll go with, start with an interesting provision, because I've looked at this for a while and assisted a student with some research on this, and that's section 69 that deals with direct marketing and spam email. So in the past, right, we could, as organizations, just attack any consumer with emails and calls and just bombard them, and they'd have to opt out. They'd have to say, stop contacting me. So POPIA changes that mechanism and makes it opt-in. So other than a few exceptions, such as if they're already a client of yours, you've got to have someone's permission to contact them. So that little tick box that you say, yes, you can contact me and sell me things. And that's a fundamental change for many businesses who've been relying on bought databases and maybe, let's say, less than ideal practices in terms of how they contact consumers. So as Rakhee said, the whole game here is about selling things and positioning your product to the right people and knowing who those right people are. So that's going to change things significantly. Businesses are starting to come around to it, but surprisingly in June, I'm still getting calls by large entities or largish entities saying, well, how do I do it? What do I do with that database that I bought 2 years ago? Do I have to go and recontact everyone in that database? How am I going to do things? And it's looked at as a bit of a let me say, a grudge, almost like a grudge spend. Now I've got to spend time and money to do this and change this, and I don't want to. I want to just carry on doing things the way I've been doing. So I found that probably one of the most interesting sections, and probably there's so many, I could probably pick many, but the other one is the regulator. So we're going to have this whole entity which is staffed up and is ready to rock and can fine people up to 10 million and put people in jail, and it's got some serious teeth. It's got some very credible people in that organization who are skilled up and ready to go. So we're waiting. I think they're going to make an example of someone, I suspect, in the time to come. So those are, I think, two big ones that stand out for me.
So for me, funny enough, and I think this is always a starting point, but sometimes missed, and it has been the most challenging provision thus far, is the application of POPIA. So when does it actually apply to a certain scenario? And most people are sort of defaulting and jumping the gun and saying, of course it does, without thinking, or saying it doesn't apply without thinking. And there is that lack of understanding around when POPIA does apply to a certain activity. So looking at that provision, it speaks about, the intention is that processing activity must intend for personal information to form part of a record. Sometimes if that's not happening, POPIA doesn't actually apply. The other one is about the fact that, whether you're domiciled or not domiciled in South Africa, but where is the processing activity taking place? Many people are under the misconception that if you're dealing with South African personal information, then POPIA applies. That is not our threshold, or that's not the basis. The basis is, where is the activity taking place? And interestingly, I had a client that determined that even though they were providing services to hundreds and thousands of consumers in South Africa, they had no processing activities in the borders of South Africa. So really fascinating, but taking conservative views at the moment, because we don't as yet have enough guidance. There hasn't been enough time for the law to be fully enforced for us to understand and get to grips with some of the deeper issues. So that one's been really interesting. I don't know if you want us to move to the next one. Your question.
I think we do have one question, which I think ties in to what you said, because I'm also quite intrigued. How is it possible that you can render, I'm not sure if it's a service of your client, I know you can't give names and anything, but speaking on a purely general basis, how can you conduct business in South Africa but not process personal information? That for me is almost mind-blowing. Can you maybe go a little bit deeper without giving too much away?
Sure. What we eventually applied for the client was that they used third-party service providers within the borders of South Africa that effected and gave effect to the products and services that they were rendering. And insofar as they themselves were processing personal information, all of that took place by persons sitting not in South Africa and on servers not hosted in South Africa. And anything that was in South Africa was literally just forwarding information as is allowed by that provision, and sort of negates its application. Very fascinating, but I don't know if anyone would be convinced by that argument, because it seemed very obvious that like, why would you not be processing information in South Africa? So super technical, and things like data flow maps and diagrams really come into play when you're considering the broader compliance aspects with this law. And what I mean by that is understanding, an understanding of all of the personal information that you're processing and where it's moving and how it's moving. So that part's really getting very fun to work with.
Mm-hmm. Okay, it sounds very interesting. We've got one question which perfectly fits in with the discussion we're having now. And it asks to the panel, will POPIA be applicable to an unregistered business? So I'm assuming you're not registered as a private company with the CIPC, or you weren't previously a CC, or you're not a trust or any registered entity in South Africa. Does it still apply to that business? To, for example, a sole proprietor, how must they handle their activities?
Sure, I'll go, and then Lee, if you want to add, go for it. But if you're a responsible party, you can be a public or a private body. And in terms of a private body, it does include both, individuals operating sole proprietorships, as well as juristic entities or partnerships. So even if they're an unregistered business, but they fall within those kinds of categories, and then we do the test. Are they processing personal information? Is that information forming part of a record? Are they domiciled in South Africa, which they're likely to be? Then yes, POPIA applies to them. And I think besides that one exception of a client, right? In almost all other instances, almost every single organization in South Africa will be processing personal information of data subjects and will need to comply with POPIA. Even if they have no customers and no suppliers, but they have an employee, they are processing personal information. Many people forget that data subjects are broader than just customers and clients, and yeah.
Okay, so if I were to just maybe go back, I think the second part of the question was about the GDPR. So if we can get your views on what do you think? Because for example, I come from an organization that is Swedish-based, meaning that our systems, we are already GDPR compliant. If a data subject needs to access his information, there's a process in terms of POPIA. Now, a lot of my fellow colleagues have said to me, but Yukthena, we are GDPR compliant. We don't feel like we're far off. I've even had people tell me that they also comply with POPIA. That's just another way. I think a lot of us have heard it. If it's not POPIA, you've heard people saying POPI. So can you just guide us? Because I know a lot of people have this, I think it's a misconception that you would automatically be compliant. Maybe you can break down just what it means from a GDPR perspective to comply, and then those steps for POPIA compliance.
Sure. So maybe what I can start with saying is how they differ. So they're very similar. They're different shades of the same color, trying to achieve the same thing, but they're not exactly the same. And the short answer is, does GDPR compliance automatically equal POPIA compliance? No, but probably. That would be my answer. No, but probably. Give you a typical lawyer answer. You'd need to consider the data, then the way that it's collected, where it's stored, you'd need to look at the situation with specifics. But I think it's very close. So if we look at some of the differences, there's some nuances with the terminology, but it's very similar. In fact, POPIA is wider in some respects because its definition of personal information includes companies. So GDPR's doesn't. That's one big starting point difference. So the very definition of personal information in the GDPR doesn't include juristic entities, whereas POPIA does. So that might, for a start, influence the way in which you do things. As Rakhee said as well, the POPIA, I think it's section 3, the application of the Act, is quite different to the GDPR's, which is extraterritorial, which means that even if you're not based in the EU and you're dealing with the data of an EU citizen, then you're going to have to comply. Quite how the enforcement and other things, that's a separate issue. I guess in theory, the question is, would you have to comply? And the answer is yes, you would. So there's some other differences, but I won't maybe take all of them. I'll pass over. There's a couple other quite small ones, but I think the big ones being, I may be sorry, Rakhee, I took the easy ones. The big ones being the definition of personal information and the territorial scope. But yeah, they're very similar.
Yeah, I mean, spot on, completely agree. And in addition to those, the other big difference is under GDPR, there is no mandatory obligation for all organizations to have a data privacy officer. There's only certain companies that meet a specific threshold are required to have a data protection officer. Under South African law, an information officer is by default to be the head of the body, whichever it may be, and with some opportunity to authorize another person to be that information officer. And so that's one key difference, that there's a specific person held accountable. I think one of the other interesting ones is the scope of criminal liability under South African law, and all of South African laws love to make criminals out of all of us when it comes to compliance. So lots of scope for criminal liability as well. And then perhaps some of the other differences is there are some mandatory principles under GDPR that are not seen in POPIA. So that's like privacy by design. So that's a legislative requirement under GDPR, whereas in advising clients under POPIA, that's a best practice, to follow privacy by design principles. So those are just a few. There are one or two additional ones. Perhaps the other one that's quite important is breach notification. So under GDPR, you have to notify within 72 hours, whereas under POPIA, you have to notify as soon as reasonably possible. And then GDPR has been around for a year or two. I guess it's 3 now. So they actually have thresholds about which data breaches must be reported, whereas under POPIA, all security compromises must be reported, which is also a distinction. I completely agree that compliance with GDPR does not mean compliance with POPIA, and it's something that has been quite interesting to navigate with these international companies and people who have spent so much money in trying to, and dedicated so much time in ensuring compliance with GDPR, only to find out 3 years later that their job's not done and there's a little way to go. So when it comes to sort of plugging the gaps, if you are GDPR compliant, you have done a lot, but there's still a little bit more to do. Getting some feedback from there.
Yeah.
I think there's an attendee whose mic has just sort of switched on. Perhaps by mistake.
Can we ask admin to just check what happened quickly?
Okay.
I wonder if admin could just on the right click and mute that person. I don't have the ability to.
There we go. I think that's
okay.
Thanks.
Okay, perfect. Sorry for that, Rakhee. You know, when you go live, you have to take it as it goes. You roll with the punches. So
no, absolutely.
As you're seeing, I think the last part was, it doesn't mean you're going to be compliant with both immediately, and you are going to conclude with just maybe some of the steps.
Sure.
Yeah.
So the one big difference is in South African law, we have a different piece of law that complements POPIA, which is PIA. PIA is the Promotion of Access to Information Act, and it regulates the way in which people can get access to information. And fundamentally, there's a requirement to have a PIA manual. There's been some interesting chatter in the background about this PIA manual at the moment, but there's no certainty. I haven't seen any law about it, so I'm not going to sort of say that but anyways, everyone needs to have a PIA manual. That is a legislative requirement, and it's part of the information officer's responsibilities. And so that does not exist in the EU, and nobody who complies with GDPR has one. So that is one of the first things that needs to be done. The second is the impact around juristic persons. So all of their compliance initiatives are geared towards personal information of natural persons. That entire program needs to be expanded to include personal information of juristic persons. Sometimes that just means tweaking policies and agreements and documents. And then from a more operational perspective, it means, looking at your systems and broadening the classification of personal information in that way to extend to the juristic persons. But I'll hand over to Lee if he wants to just add a few more.
Great. So the other interesting point that I've come across recently relates to also Section 3 and the application of the Act is data de-identification, particularly in the health space, both research and medical professionals, because they clearly need to rely on quite a lot of personal information, but to what extent can they use it once it's been de-identified, and what quite does de-identification mean? In the US, they use a term anonymization. We've gone for de-identification. And then in the GDPR, they've got this other term, pseudonymization, which is basically masking the data, which is not quite de-identification. So you've got these three different sort of variables. And one thing with the GDPR is it's been around for longer. So there's more guidance notes. There's more sort of information flowing around on how to deal with it. Our regulator hasn't had the time to do those sorts of things. So we're hoping that there's going to be some guidance on how an entity can de-identify data, what that means, because there's been some misunderstanding. So for example, if a team of researchers has an Excel spreadsheet with a whole bunch of data and they can't quite identify the data subject, but someone in their organization can, in our view, that's not properly de-identified, and then the Act will still apply. So there's some misunderstanding and some argument, frankly, around that. I always tend to take quite a conservative view, look at the legislation, look at its wording. So there's some more to come there, I think. So if you're in the health space, look out for how to deal with de-identification. And I think also allied to that, one of the other distinctions that I've seen is this right to be forgotten doesn't quite exist in POPIA. And you've got slight nuances, and as I think Rakhee correctly says, is you can't say I'm GDPR compliant. That means definitely POPIA compliant, because quite a few clients I've got the impression from, they assume that because they're GDPR compliant and they come from the great Europe, that means then that we are down here in Africa going to just easily comply, and that's often almost invariably not the case, because there's more steps, as Rakhee clearly points out. So, but they're close. So if you have a GDPR compliant entity that comes from Sweden or wherever, you know, you're just a few tweaks away and one or two little process shuffles down the line, and you should be compliant. But one does definitely not equal the other. And like I said, the way that I've tried to explain this to other clients is different shades of the same color: dark blue, light blue. It's the same, it's blue, but it's just slightly different.
Muted myself. This is what happens in your life. I think that's brilliant. I think you've more than covered what I could have possibly asked for. And I think that saying it's such an interesting way to understand these data privacy laws, is it's just a different shade of the color. So you add a bit here, you take a bit away, and it's the same, but it's not the same. So yeah, that's very interesting. Thank you. So Advocate Lufuno, you've been very quiet. It's your time to shine, and Rakhee as well. So we know that companies have until the 1st of July to comply with POPIA. And if companies fail to comply with certain provisions of POPIA, that this can result in the newly formed regulatory body, which is known as the Information Regulator, who can impose an administrative penalty of up to 10 million rand as of the 1st of July, which is when that grace period ends for compliance. The other scary part is the fact that you can also have imprisonment for a period not exceeding 10 years. Or to a fine and imprisonment. Now, I think the biggest question is, what are the different stakeholders, the different players in the game to this regulation? What is their attitude towards it? And I think for me, coming from a compliance background, I'd also like to know how players in the game are looking at this from a compliance perspective. And if you could maybe start the conversation there by looking at drivers of compliance. And then the other thing is, I would ask the need to actually respect the privacy rights of data subjects, okay, as a company now. Is that what I have to do? Must I actually look at my processes and my framework so that it respects data subjects' right to privacy? Or, I mean, at the end of the day, we are all trying to avoid sanctions and criminal prosecution. So from that perspective then, Advocate Lufuno, I'm going to ask you to kick off for us on all of these compliance issues, if you can maybe give us a background.
Thank you so much. Somebody tried to call me. I'm using my phone. I do apologize for that. So your voice has even gone down. But anyway, I will start with the issue around the attitude. My observation working with different players, I see that players are realizing that achieving compliance is not just a tick in a box, which used to be the case previously, because they can see that it's not a good business strategy to tick a box, because you, as my fellow panelists have already talking about some of the issues regarding the Cybercrime Now Act, you are dealing with cyber criminals. So if you're going to do that for ticking the box, then you have a challenge on your hands. So from the interactions that I've had and the webinars that I will attend, Brainstorm, Tech Central, and others, I can safely say that there is a genuine desire to comply, because players are realizing that the more you comply, you actually minimize the security and financial risks that comes with non-compliance. And so I can say that it's not an issue of we are fearing sanctions, but it's now becoming a business decision to say we need to do this for the sustainability of our own business. Because I believe in 2019, when we're going 2020, there is a quite, I think it was a marketing or sales organization in the US that has to close down, and 300 people had to lose their jobs. And it was simply because maybe they were ticking a box and that attack came to them and they were totally unprepared and they had to shut down. So there are just too many consequences apart from the ticking of the box. You know you're going to suffer more consequences, including losing trust with your clients, losing the reputation. So if you lose trust and reputation, it's really not an easy thing to come back because people no longer trust you. It's difficult to actually come back to business. So if you're a big business, maybe you can survive. But if you are not such a big business, if they were even to fine you 10 million rand, then you rather go to prison because you won't be able to afford it. So the major drivers in terms of, or it's one driver of compliance, as it was said earlier, to say that data or information is the main oil of every organization. So if you don't have that oil, it means your machine is not moving. So the pandemic and requirements for people to work remotely, I believe it has made many organizations to realize how vulnerable they are in the cyberspace. Because when we were in the building, sometimes we would have thought that all is well. But now having to manage people remotely, and most organizations were caught off guard, didn't have the remote work strategy. So it was a bit of a difficulty. And as it was said by my fellow panelists earlier, the target now for cyber criminals, they are no longer bothering with targeting your network, they are targeting the staff, because they know now the staff at home, they are vulnerable. So it's easier. Like if you look at the Experian case, it was an issue of social engineering. They didn't break anything. It was just a phone call and that was it. So I believe that organizations are seeing that protecting organizational data is no longer an extra optional. It is something that you need to invest in, and it is something that is becoming more and more prevalent in boardrooms. I believe more CIOs are very excited, and where organizations have the CISOs, they are very excited now that they don't have to be going there and begging to be recognized. Now cybersecurity is becoming an issue for everyone. As it was said earlier, that it's not an issue that we think is for the CIO, is for this person. It is for the whole organization, because if we don't understand it from that perspective. So I am seeing that people are coming together to understand it as an organization, not as something that is like, if we can have time for it. It is something that I believe is becoming on top of the agenda. So I don't think that it is being done because people are afraid of sanctions and criminal prosecutions. But the issue about respecting the privacy, I gave it in a way 2 different answers, because it's depending, in my view, on the organization's values. So if your organization's value is that we want to be trusted by our customers, we want to be reputable, we want to ensure that we're compliant, and our main aim is to ensure that we're protecting the data that we have, then you will make efforts to actually protect the data, not because you're afraid of sanctions or criminal charges. But if it is for surveillance capitalism, which was highlighted throughout when my fellow panelists were speaking, then it means that whatever you do as a surveillance capitalist, you do it for the eyes of the regulator. but underground you are busy making sure that you are still selling our data and you're still following everything that you do. And so it really is not an answer that you can say everybody from the business perspective, they are doing it because they are respecting the privacy of the people. Because already we can say that surveillance capitalism is huge and it's making a lot of money for those who are doing it. So within that context, I think the regulator will have a bit of a lot of work to ensure that the right to privacy, as is in our constitution, must be respected. And I believe we'll talk about the example of WhatsApp as we continue. Thanks.
Thank you so much. I think, Rakhee, if you can also give us just some of your drivers for compliance. And yeah, is it just tick box or are you seeing genuine compliance?
So initially, I think, especially exactly like Advocate Lufuno has said, COVID has really changed the perception of compliance with POPIA. Forcing people to work from home has exactly demonstrated the vulnerabilities in people's organizations, and that's really sped up or improved their desire to ensure that they are compliant with POPIA. Before that, it has been a struggle to advise clients properly, legal and the compliance officers and the IT teams, they understand why it's an important piece of law and the work that's involved, whereas the board and senior management may not have always been, part of that discussion or on the same page. So in the beginning, I found that people were doing it more as a tick box exercise, but especially those that have done it as a tick box exercise in the last few months leading up to this, this end of June deadline, they've really come to realize that there is more to it, and they are trying to give effect to their requirements a bit more deeply. So, especially from the questions we're getting from clients, you can see that they're thinking about it better and they're understanding that there's benefit in it. One of the things I like to tell my clients is, as a person yourself, whose information is being used by other companies, how do you feel about the practice that you just suggested? Because it's very easy to sort of disassociate the compliance from the people, but this has real world impact. We're talking about people's personal information and how it's being exploited, and that forces them to see it from a different perspective. So the attitude towards compliance has changed drastically in the last few months, I believe. And the major driver at the moment is the need to be relevant. So these days, businesses, companies, big organizations are not doing business with other companies if they are not respecting the principles of personal information processing, because it is a massive risk. It is a massive organizational risk. As Advocate Lufuno says, the impact of a data breach is more than just the information that is lost. It's the reputational risk. People have suffered share price drops, the value of that business, the trust that customers have in you, the brand impact, it's just massive, outweighs the penalty that you may pay at some point in time. So with that realization, that has led to the client's drive being much more aggressive.
Thank you so much. Okay, so I'm going to snap back to you, Advocate Lufuno. So I think one very hot topic, a very, very interesting conversation, and it's been going on for a while now, is in respect of WhatsApp. So the messaging service, WhatsApp. Now, WhatsApp's updated their privacy policy, and Advocate Lufuno, you wrote an interesting, a very concise and insightful article about how to delete WhatsApp, and I think this was back in February. Now it appears that WhatsApp is somewhat backtracking on its earlier stance in that it was going to limit certain functionalities to users who fail to accept the updated privacy policy. meaning that users now have the option to actually refuse the privacy policy. And WhatsApp claims that it has arrived at this decision after several consultations with governments across the globe. Now, are you aware of any efforts or public advisory issued by the information regulator advising people against accepting WhatsApp's updated privacy policy? What do you think WhatsApp's end game might be in this regard? And finally, in light of the options now presented to users, would you still advise people to opt for alternative messaging platforms? I know from my own experience when this whole drama came about, I looked at two different ones, Telegram and Signal, and they were pretty much the same as WhatsApp. I favored Signal because it was just a little bit easier to use. So from your perspective, and that interesting article that you wrote, what could be going on here?
Thank you so much. I will start by the question you didn't ask. I just want to agree that
Yes.
when WhatsApp issued that policy and we heard about it around January, they had this vigor to say, you know, either you take it or leave it. It was that kind of an attitude that we were getting from a user's perspective. But at this moment, I can say that vigor is no longer there. I have engaged personally the support team because I needed to investigate it using my own account so I can understand what is happening with the policy. Because remember, first it was supposed to be February to be implemented, I think the 8th or the 9th. And then there was an announcement to say the 15th of May. And when we were getting to the 15th of May, it's like, okay, they're going to give us another date. So I don't know of any communication that came from WhatsApp to say we are withdrawing that policy. But I know for a fact that the tone is no longer you take it or leave it, because they could see that by introducing that policy, they've given Signal and Telegram a whole lot of business. Yes. So users started in a way which is, I can applaud, to say, you know, we can also make our own choices. Because normally when you are in this situation where it seems like you don't have anywhere else to go, there is that sort of a bullying kind of a thing. But I want to believe that they had realized that pushing it like that might not be a good business strategy. As far as I understand and as far as I am interacting with the support team, there is no opt-out option available yet for the users. But from the article that they have put there to say what happens at the effective date, they are practically saying that nothing will happen to you. So whether you accept it or you don't accept it, so far they're just saying nothing will happen, because remember before they were going to lock you out. And so I haven't accepted it. I have told everybody bye, because I was thinking anytime I will be locked out, but I'm still connected, so okay. The efforts I am aware from the information regulator, I cannot say to the public they've gone to different radio stations or whatever to say for each community, because remember, accessibility is an issue, and accessibility includes language. So if I can say that I've seen the chairperson speaking on SABC1 on the news being interviewed, I cannot necessarily say that was a communication that was sent out to the public to say, we are advising you to do this, which maybe I would understand in a way, because as a regulator, you cannot necessarily go out and tell people not to follow a certain service provider because there might be legal implications. So I believe obviously there are most lawyers at the regulator, so some of these things they're doing them under advisory. However, I'm aware that the regulator has been working very hard to get Facebook and WhatsApp to revise their policy. Because as you say, what I wrote on the articles is that there are two different policies that they've issued. There's a policy for everybody whom they don't respect their privacy. And there's a policy for the EU and I believe California. So my issue was, I mean, if you can give EU and California their right to privacy, why can't you do that to everybody else? And I think as my other panelists have been saying, is the two shades of the same color. Is that what was said?
Yeah, different shades of the same color.
So, and most of the things we have put in POPIA, we actually had taken it from the GDPR. So I was not understanding in terms of why was that. And I was happy to see that also the regulator doesn't understand that kind of thinking. To say, if you are able to respect the rights of certain countries, why can that be universal? So within that context, I know the regulator has been doing something, and even if like you check on the website, you can see what they've listed to say has to happen, and Facebook soon has to go and account to Parliament. So I'm happy with what the regulator is doing, and I support it because our constitution protects our right to privacy. So if you are a country operating in South Africa, you need to abide by the laws of South Africa. It was the other question that was asked earlier to say, you are operating here, but you are processing data somewhere else. But within the EU context, it doesn't matter where you are processing it. So long as there is a EU data subject within that processing, wherever you are, you need to follow the rules. So it has to be the same way with us. So really, that's just my view in terms of how we need to approach it. Their end game,
yeah,
I believe, as I said, 5 January, you have this announcement, 8 February, you'll have this happening. Then, oh no, we change our mind. It's 15 May, oh, you can still use it, we won't do anything. So I think for me, there is a realization from a business perspective, because we have heard in the beginning how much was spent to buy WhatsApp from where they bought it. And now you need to do return on investment. So I do not suppose something that they can see is affecting the bottom line. You can insist on it, because what I saw from the users after obviously they were alerted, me and other people who were writing about the WhatsApp policy and advising the public, there was this daring from users to say, you know, we have alternative options, so let's wait for the 15th and see what you're going to do. So I believe that the end game is to say, if you look at the policy of 2016, in actual fact, WhatsApp has been collecting a whole lot of data already, because I also requested my own data to see what they are collecting about me. They have actually everything. They know when I logged out, when I logged in, who I spoke to, the whole contact list is there. It's like, oh gosh, they know which phone I'm using, so they already are collecting a whole lot of information based on the 2016 policy, which are accepted by default, because remember when it was sold, it was like everything will remain private. So you were still moving from that trust that came from the original owners, not knowing that things will change. So I believe they can still make money in a way. So that's why maybe they are relaxed. So I believe that within this same breath, when they say they've consulted with this government, I've not seen any update on the policy to say, after consulting with this government, this is what we have come to. So to me, I think it's just a cat and mouse. Whoever take it, because they are still sending those messages to say,
yes,
agree to the policy, agree to the policy. So it means the more they do that, there are those who are afraid, like, oh, I don't know how Signal works. I don't know how Telegram. Let me just accept this thing. So there's just that thing to say, no, let's wait and see. That's what I am seeing. And I think we have been talking about the issue of surveillance capitalism. So for me, that you could see how wide this surveillance capitalism is at work in the way that even the policy was introduced, and now we're like kind of playing a cat and mouse kind of a thing. So I can't really what is it that they're trying to do, but I believe that seeing that they have uplifted Telegram's business, and they have I didn't even know Signal existed before this saga, but I knew about Signal immediately after that policy, like, what is the alternative?
Yep.
Like, oh, the Signal. So yeah.
Okay, so that's brilliant, and I'm really enjoying your energy. You can see when someone is passionate about what they do. So I'm going to keep you on with me, okay, for one more, actually two more questions. So I think the next one will go more from the lines of, I think, Poppy, and we'll jump into, I think everyone is dying to know now with the Cybercrimes Act, hey? In terms of prevalence, types, and target of crimes. Can you give us an idea of the current state of cybercrime in South Africa and why South Africa has become a prime target for cybercrime? Is there other legislation as well? So besides the key legislation that we're dealing with today, which is the Cybercrimes Act, currently in force, that will help to tackle the wave and spread of cybercrimes in the country. I think, yes, you've got that passion. If you can take me through that one as well, I'd really like that.
Okay, thank you so much. The current state of cybercrime in South Africa, so I really didn't put much. I just wanted us to have an idea that we are definitely naked in the cyberspace. No, I like to put it like that so we understand the extent. I hope no one is offended. So according to the insight into the cyber threat landscape, which is done by Accenture on South Africa, the way the cyber attacks have increased, it was said earlier that we are placed on the third highest, we are on the third country that is most attacked. So I believe most of these attacks are the bank fraud, the tender fraud, SARS fraud, those emails they send you, but SARS forgot to pay you something. Yep. Yes. So most of this money, the 2.2 billion rand, I believe is coming from the individual victims whose data is held by these other people, that the responsible parties, who I can believe that they are not necessarily taking care of the data that they are having. And at the end of the day, the mass is the one that is suffering. And last year in 2020, I saw when I was reading somewhere, it's like you can't mention, but I can tell you that you have seen that Parliament was really embarrassed, right? During one of their video meetings. That also happened with the Department of Women. There was a system that was shut down for 2 months about here in the city, and it's a government entity. So it means for 2 months, as a public entity, you are shut down for 2 months. You are struggling to put yourself together. So you can even see that there's not even disaster management strategy in place to say, okay, if this happens, can we still continue to work? There's no continuity plan anywhere. So you see that even with private sector, as we gave the example of Experian, the banks were being attacked one after the other. And so you can see that we are kind of relaxed when we come to this problem. We know it's a problem, but I don't think there is enough investment that says. I was attending an interview yesterday for this council that is being established, so I want to be part of it. And the reality that I gave them was that I've listened to all the budget speech since COVID. I don't remember one that mentioned anything, this budget is for cybersecurity, or this budget is to fight cybercrime. Not one. The money is going everywhere else. I was even laughing, saying, you know, we do this PPE. PPE, we are wearing them, putting them in a dustbin. But in the cyberspace world, we are so naked that we are a playfield now. So that is why I think our state of cybercrime is not going down, because we are not prioritizing, as they said earlier, your data security, your data protection, so you can achieve data privacy. We are not prioritizing those things. And more importantly, we don't have skills. So yeah, for me,
if I can maybe also throw to you a bit of a technical question, right? It links right in with what you were saying. Is that other experts and commentators have noticed that the version of the Cybercrimes Bill, which was passed by the National Assembly in November 2018, and now assented to by the president, that it differs substantially from the versions of the bill published previously, okay? Now, this raises very serious concerns about what is government's encroachment on freedom of expression and freedom of the internet. And some people feel that it fails to strike a balance between the interests of the state in securing cyberspace and individual freedoms and rights. What has this new version that we're looking at left out, and what would you say makes this new version that was signed into law different? Now that this bill is law in South Africa, what are some of the most practical or significant impact that it will have leading on to what you were saying about cybercrime?
You see, as I said, I was attending this interview yesterday.
Yes.
I think this type of a question came. My personal view is that sometimes when we do these things, I don't say they become, we have politics, but we have vested interest that in a way, when we are discussing certain things, it's like, I'm thinking about how it will affect me, not necessarily how it will benefit the country. My view really, honestly, before I come to the difference and the similarities, I did not see the reason why the whole part of cybersecurity had to be taken out, because if the intention was that we are for the country and to ensure that it's protected, whatever it is that we said, it was the huge, the lack of balancing. With all the experts, I'm sure we would have been able to assist with the balancing act. But anyway, that is just my view, because for me, the cybersecurity is creating the governance to say, this is how we want to create a secured environment that is compliant, and this is how we want to create a culture that everything we do, we breathe and eat this cybersecurity thing. So, because if you don't have a cyber secure environment, you are vulnerable. So even if we list the crimes and people don't know how to prepare themselves to defend this thing. So in my view, I think it's still imbalanced. I understand that there are those who are clapping hands to say, oh, the act is out. Yeah. But as it was said earlier, we have these bits and pieces here and there, and we were told the intention was to bring everything together. So that problem still is there. It's not solved. Okay. So it left out everything, cybersecurity, the bill. it just then went out with the cybercrime, cybercrime, and it was indicated earlier what the Act now is saying, so I won't repeat that. The Act, in terms of the practical and impact that the Act is going to make, if you look at the ECT Act, which was said earlier, I believe it had 3 sections that were dealing with cybercrime. And it was said that that is too narrow in this world where the threats are growing every day, and the crime is like they are creative every day, the cyber criminals. So that was not covering it. So it expanded the spectrum in terms of what will be considered cybercrime in South Africa. And it also gave the law enforcement agency a wide spectrum where they can work. Because if you go there, you say this is what at least the Act is providing for that particular crime. And I liked the provisions where they provided for mutual assistance, which I wanted to tie in with the provisions that are dealing with jurisdiction. Because it means that if it's done somewhere else, but it's affecting us, then mutual assistance at least comes in, and it also assists with the skills that we currently don't have. So I like that. And the issue that they specifically spoke about capacity, for me, it was like clapping hands. So if we really do implement this Act, the fact that we've always been crying about our law enforcement agencies not knowing how to handle anything, that's why earlier it was said that the crimes that were listed in the ECT Act were not really fully implemented or enforced, because the ones who are to enforce it, they don't necessarily have the capacity to actually do what they're supposed to do. So I was very happy to see that. What I also liked was that it linked with other acts, like by name. Example would be RICA, the other example would be Protection from Harassment Act. So this Act didn't come in as if the normal way we know it, that an Act will just come siloed as if it is, eureka moment. But this one was able to be bringing in to show you where which Act comes in. I believe POPIA is there, but I didn't have to mention it here because obviously we have already done the issue of POPIA. So I hope that covers it. I didn't answer some questions, but I think it's okay.
Thank you so much. If I can just loop Rakhee and Lee back in. So in terms of from a compliance perspective, what are the main clauses, in your opinion, from the Cybercrimes Act that businesses should be aware of?
Okay, so I think unlike POPIA, the Cybercrimes Act for let's say the ordinary business doesn't have as many provisions per se that they need to comply with. I think the big one would be, the first starting point in my view is looking at the type of business. So if you're an internet service provider or in that field, there are going to be significant obligations on you. Also, if you're a financial service or financial institution, then there are obligations on you, primarily reporting obligations in terms of Section 54, and that if there's an offense that's been committed on your network, you need to be able to go ahead and report that. Further, the service provider needs to, in times, a little bit as has just been mentioned, there's a link here to the Protection of Harassment Act, the sort of cyberbullying legislation, where there might need to, if you're an ISP, you might need to provide law enforcement with information about a user so that we can get a protection order issued. So look, in short, there's not as many obligations, and you need to look at your business type before even determining whether any exist.
Okay.
Okay, thank you.
Advocate Lufuno, you can just give us some. Yeah,
I don't think there are many, but I picked out what I think they just need to be aware, like they are bound by data privacy laws. my summary, because you can't just disclose the information anyhow. There need to be a legal reason to do that. So they need to be aware that the information has to, however they disclose that information, it has to be compliant to data privacy laws. And they should cooperate with the investigation as investigating officers. So if the investigation officers say, come and say this is the information they need, not complying with that is an offense. So they need to know that it's not like they are doing the investigators a favor, which is like now, because it's very difficult to do a Section 205 at the moment. You get the run around, like most of the crimes that we actually have in the banking sector, in the tendering sector, it is because to get that 205 application done is like, I don't know. Then they are obligated to report unlawful activities. Like if you realize that if it's a bank, they can see if somebody is actually now defrauding me because of the type of activities that are happening in my account. They can see, but this is not her behavior. So I know Standard Bank does that. If you swipe once, you swipe twice, they will be calling you to say, are you sure it's you who is swiping that card? Because so it means immediately if they see that it's not you, they will lock your card and they will be able to also report to say, at this ATM or at this place, this is what's happening, which will be the same way with your Vodacom and your Telcom to say if they can see somebody is trying to do a SIM swap, it's not yours, then you are found out. And so if they notice that there is something that is happening which is not in the norm, they should report that. They should initiate to report it to the police. So those are the three things that I picked up, and if it worked, I think this will really help a lot. Thanks.
Great. Rakhee, so I did ask you if you can maybe give us some comments. So broadly speaking, can you tell us what kind of persons or entities does the Cybercrimes Act cover? Who does it apply to, and what kinds of offenses are created, and what are the penalties for committing cybercrimes or for non-compliance with the Cybercrimes Act requirements?
So interestingly, it's really not like POPIA in terms of its application and what it's trying to achieve. It's a criminal piece of legislation which has a very different place in law compared to compliance laws. So with that context, literally it applies to anyone and everyone. So if you decide to commit an offense or you want to commit a cybercrime, then you'll be caught by the act. So fundamentally, all the cybercrimes that are enforced or will be enforced, apply in that instance to somebody that's committed the crime. So firstly, there needs to be the unlawful and intentional action. I think it's quite important to point that out. So you can't just by mistake commit a cybercrime. You have to have the intent, and it has to be an unlawful activity that you are participating in that lends itself to a cybercrime. And then the actual cybercrimes go into quite a bit of detail. So there's quite a few of them. I'll just pick on a few. But essentially unlawfully accessing data or systems, unlawful interception, doing something that you shouldn't be doing, so unlawfully using or possessing data or computer programs, interfering with it, and they are aggravated offenses as well. So very technical terms, they require a little bit more explanation if you did want to understand the specific cybercrimes. But essentially anything that you think would ordinarily be a cybercrime is now a cybercrime under the Act. And in addition to that, there are some other specific cybercrimes like cyber fraud, cyber extortion, cyber forgery and utterings, and theft of an incorporeal property. Those are also additional cybercrimes. And then there's a separate section dealing with malicious communications, and that part has been missing comprehensively from the law, and that's the cyberbullying part that has already been mentioned by the panelists. But if you're using data messages to incite harm, to damage your property, to threaten people or share intimate images and the like, then you would that's also now a cybercrime under the Act. So some of them have been much needed, as Advocate Lufuno has mentioned, trying to actually get remedies that give justice to people that have been suffered or being found themselves victims of cybercrime has been very difficult. And this now changes that position drastically. There'll be some time needed to build in that infrastructure to allow people to be able to access their remedies, but that in a nutshell is some of the cyber crimes. I think I'm missing one of your questions that you may have asked. I think it was around also who else does it apply to, but it was covered in terms of electronic communication service providers and financial institutions who now have that obligation to report.
Okay, and then just in terms of when it comes to restrictions, specific requirements, exceptions, okay, for the transfer of personal data from South Africa, so from our borders, if we're transferring it to a third country, is there instances where you must actually inform the regulatory body before personal data or personal information is actually processed?
So it's actually a loaded question. So firstly, under POPIA, there's provisions dealing with transported transfers of personal information. That section starts with a prohibition. So it says that any person in the Republic cannot transfer personal information out of South Africa, except if you meet certain exceptions. And those speak to things like having a binding corporate rules between a group of entities, a binding agreement with a third party, consent from the data subjects, where it's necessary in the conclusion of performance of a contract. So those are some of the exceptions under which you need to be able to demonstrate in order to be able to transfer that information out of South Africa. Mm-hmm. In addition to that, there's a separate section in POPIA dealing with prior authorization. This talks to the information regulator having to be approached to give approval before transferring special personal information and personal information relating to children out of South Africa to a third party in a country that does not have adequate laws similar to POPIA. So in that instance where a responsible party intends to do that, they actually do need the prior approval of the regulator. In addition to all of that, we do have the now draft national policy on cloud and data that was published. It is in draft form. It's very high level at this instance, but it does suggest that the government, the legislators are looking at implementing some kind of law restricting the transfer of citizen data out of South Africa. Now, which categories of citizen data it may apply to, that hasn't yet been expanded upon. So if we look to other jurisdictions who have similar data localization laws, you'll see that they generally do restrict it to specific categories such as health information or very sensitive military kinds of records and other types of information. So we'll have to wait to see what the new laws that will be drafted to give effect to that kind of policy will include.
I do note we have run out of time. If I can just have a few more minutes of your time kindly, just to cover, I think we've done a good job. You guys have done an excellent job in covering the subject matter. So I think we just have a question or two that ties everything together. Would that be okay with you, Rakhee?
Sure.
Okay, perfect. Can I get a thumbs up from Lee and Lufuno? Okay, good. So we've just got about 2 or 3 questions left. So Advocate Lufuno, if I can throw this one to you. So last year alone, 80% of organizations saw a rise in cyber attacks. And apparently there's an attempted cyber attack every 28 seconds. So this spike in cybercrimes coincides with the wave of the COVID COVID-19 pandemic, when many people, we suddenly had to work from home when the national lockdowns, for example, started. Now, cybercrime continues to rise, and it's not going to stop. From a practical perspective, what measures can individuals and corporate organizations take to prevent themselves from becoming cybercrime victims, or at least, in the least, how can we reduce exposure to cybercrime activities?
Thank you so very much. I believe that prevention is better than cure. So I'm going to give you preventative measures.
Okay.
And I believe that if you create a compliant environment and you maintain it sustainably, you are likely to minimize these attacks. Because even me, even when I consult, I don't guarantee anyone that will never be attacked, but at least make it difficult for them to attack you. You know, don't stay there with a door open and unlocked. So I believe that we should start making cybersecurity part of us. Thus, we need to be intentional about being cyber aware and creating a sustainable cybersecurity culture, even as an individual. Because you find that people go to restaurants, the first thing they ask, can I have the free Wi-Fi? Don't do that. So the culture needs to be built. And I always say that when you have the best IT infrastructure, you've really invested in the best of the best, but you don't have the necessary governance in place, it still leaves your organization very much vulnerable. As it was said earlier by Dr. Swales, that you need to bring everybody together. So if you have the policymakers there, the compliance there, the IT there, it's not gonna work. And everything, I believe, should start from a governance perspective to say, where are we going, how do we want to get there, and all that. Because when you are working from that perspective, it's easier to minimize. Okay, I'm saying minimize. So you need to classify the assets in the organization, which mostly we have all agreed since this the conversation started, that the data is the oil of the organization. So if you have this asset, you have not classified it, you don't know what you are dealing with, you don't know what to protect, the level of security you need, and all that. So we also need to certify goods that we are buying from the ICT perspective. Because if you are buying infrastructure, you're just picking it from the floor and you bring it to your organization, but you don't know if it meets your cybersecurity requirements. So we need to start learning to say, you scrutinize what you buy. Like me, when I go buy food, I always read the label, what is there, before I go pay. So we need to do that as well in this context. And we need to make sure that users are accredited and are classified. You know, this one have access here, have access here. So if you don't have that, everybody has access everywhere. You don't even know when you are compromised. So you need to just do the basics, and importantly, assess the environment regularly, because we normally will have this state of the art, yay, but then we don't maintain it because we are not checking vulnerabilities, at least frequently. Because cyber criminals are not sleeping. If they come knock at this door today and your door is locked, they will come tomorrow, try the window. They will come, so you need to be always up. And we have already said social engineering is the key now. So if organizations are not training the staff, everything that they've invested in will be in vain, because cyber criminals are no longer interested in breaking into anything. They just need to convince your staff we are legitimate and they get access, and that is it. Thank you.
Sure. That's a scary one. Hey, when you have to trust your human capital more.
Yes.
So Dr. Swales, so we're coming now to the end of our session. We are a few minutes over. Dr. Swales, if I can just ask, it's one thing you create a law, and another thing to actually enforce that law. Now, would you say that South Africa, our South African regulators, have the kind of experience and human resources necessary to enforce POPIA and the Cybercrimes Act, seeing that it has now been signed into law?
Yeah, I mean, optimistically, I'd like to say yes, but realistically, probably I'm leaning more towards maybe, but probably not, but we're getting there. I know that I'm maybe sounding like a politician and I'm dancing around. So let me start with the positives. The info regulator's got has got a staff complement of experienced attorneys who understand the law, who are dedicated. So they've got the structure in place to make it happen. Whether that budget exists beyond implementation date, no one knows. It's whether there's a political will to make it happen. In terms of the Cybercrimes Act, if I look at the NPA, the National Prosecuting Authorities, they've got it's on the internet. If you just Google NPA report 2019-2020, they produce a whole lot of statistics. Cybercrime, our prosecution rate is excellent, in the high 90%. So when we get it to court, we do well. But the number of matters that go to court is exceptionally low. I know a couple of our colleagues have quoted that Accenture report where we were quoted as being the third most prevalent country in terms of attacks. And if you take that, whether we're third, fifth, 10th, we're right up there. We're on the top of the log in terms of attacks. And if you think of those vast numbers, and then if you look at the small amounts of cases, that doesn't add up. So we need more, in terms of resources, in terms of expertise. And the new act, from a optimistic perspective, I think it's Section 55, puts an obligation on the minister to adequately staff and to create a sort of point of contact. And so look, the legal infrastructure's in place. The human capital, I think we lack a little. We need more emphasis on budgets and training and skilling up. So there's more people that are able to participate. So yeah, optimistically, I think we're getting there, but realistically, we're probably not quite there yet.
Thank you. I think that's frank. It's quite honest. If I can just throw Rakhee in as well, what do you think are some of the foreseeable or assumed challenges that businesses may face in complying with POPIA and the Cybercrimes Act? So yeah, this will bring our session to a close. Well, what do you think? You've given us such good input overall. I think this is a good one to close off.
Sure. So what I think is going to be the biggest challenge is, or has been the biggest challenge, is giving effect and implementing the requirements of the law, of POPIA at least. Unfortunately, we don't have as yet enough guidance from the regulator to assist, for example, small businesses on their compliance. For them, it's really very onerous to comply with POPIA to the T. It makes no sense, and it can be extremely time-consuming and expensive, frankly. So that has been one of the challenges that not only SMEs are facing, but all organizations. And in the midst of the pandemic, when people are just trying to keep their doors open, because it's been a very tough year and a half for all of our citizens, this compliance burden doesn't help that. So that has been the challenge. But from a proper technical perspective, in terms of compliance with the requirements, it's about now expanding on the principles that they want us to enforce on an everyday basis in a way that still allows us to conduct businesses. And then from a Cybercrimes Act perspective, I actually don't foresee there to be much of a compliance burden there. It's mainly just POPIA, in my opinion.
Okay. And Dr. Swales, if I can also just,
Sure, thanks.
I know we're running quite over time, and I must apologize. I think it's such an interesting topic.
No problem. And I'm sure people are eager to leave. It's Friday night after all. But I mean, I agree with what Rakhee says there. I think that primarily, unless you're a bank or an internet service provider, the Cybercrimes Act is just a piece of criminal law that's going to regulate the space going forward. It's more POPIA, which is going to apply to pretty much every business. So that from a compliance perspective, particularly for the, the legal fraternity out of there, POPIA is probably going to be more front of mind, particularly because that date is looming. And if you look on the information regulators Twitter feed, they're having stakeholder meetings. The first one's already sold out or full. They're going to have another one in July. So yeah, they're going ahead, and I think the POPIA is probably the one to keep a lookout for now. But the Cybercrimes Act is a really good step forward. I think it's not perfect, as our colleague said, but it's a really good step forward.
Brilliant. Thank you so much. I must really thank our panel for joining us this evening. And I think the Innovation Law Club has done an incredible job of sourcing 3 of the experts in these fields. And yeah, it's so much appreciated for you to take your time to share these insights with the rest of us who have, I can say for myself, I have learned a tremendous deal this evening. So thank you for joining this afternoon. And yes, with those sentiments, it brings this session to a close. So thank you for joining us. Whichever platform you've joined, it's much appreciated. So have a good evening and take care.
Thanks. Bye-bye, everyone.
Bye.
Bye.